a lot of the cases we get. And so you have to make the decision right there. There's, it's just not fair for the person to be found guilty of that.
So prosecutors then have under their ethics rules, have a duty for justice, not just victories in court.
That's absolutely true. And that's something that a lot of people tend to forget. There are so many clear cases of guilt out there, David, that any prosecutor who wastes his time going after some of these cases that do not rise to that, it's not just a waste of time. It's something where that time could be better spent working on the folks who are truly causing havoc in the neighborhoods, and you got clear proof against them.
My listener has a question. If you're the prosecutor, if the listener is charged with a traffic offense and is cited to city court or to sessions court, and he waives the court and says, I want to exercise my right to be indicted, is he likely to be indicted given the workload at the prosecutor's office? How likely is that to get an indictment on a traffic charge?
On a traffic charge?
Yes.
It depends on the traffic charge, I guess. And the likelihood it varies. There are some cases that the grand jury no bills, and they no bill cases that are much higher than traffic offenses sometimes. But sometimes they send to the grand jury things like criminal trespass or driving on a suspended license or driving on a revoked license, which are considered to be moving violations or traffic violations, automobile-related violations, which a lot of people tend to think are very minor. So it depends on what the grand jury does.
Tell my listener about jury rights. Do juries have a right to judge the law and the facts, or just the facts? What is your position on my listener's belief that he, in the secrecy of the jury chamber, judges both?
Well, the way it's supposed to work, the way the system works, is that the jury serves as the fact finder and applies the facts to the law as the judge instructs them. So, for example, say it's a murder case, and it's a felony murder case where the defendant is charged with committing a robbery, and in the course of the robbery, the store owner or the victim gets killed. Well, the judge will instruct the jury on the law and will say, under the law, you don't have to intend to kill someone, you have to intend to commit this robbery. And if they committed the robbery, and in the course of that robbery, someone dies, and that is the crime of felony murder. The jury then hears the witnesses, hears a police officer say, I arrived at the scene, found the store owner on the ground, pulled the video, it looked like the defendant. Someone found the car that the defendant was driving, and there was some property from the store in it. And so the jury then would listen to those facts as they come in, apply those facts to the law and say, it looks like he was part of this robbery. The store owner did die, so therefore he's guilty. So that's the way it's supposed to work. However, in reality, a lot of times what happens, the jurors go back there and, the stories we've heard, about what jurors, how jurors make their decisions, they stray, they talk about all kinds of things, and whatever they come back with is pretty much final. So they theoretically, David, they could go back there and say, we don't like this law, we're going to find them not guilty, and nothing.
And there's no recourse that the judge can impose against them or upon them. There's no recourse for the prosecutor either if they elect to find one accused of a crime of some kind not guilty. It is a secret proceeding.
Correct. I've never heard of that, and in fact, there are safeguards in place to where it's supposed to remain secret.
This is David Tulis. We're talking with Boyd Patterson, who is an assistant district attorney. He's on leave in his bid to run for criminal court judgeship of Hamilton County. We're brought to you by Choo Choo Barbecue. Make sure that you have your catering done by Choo Choo Barbecue at 870-7894. That's 870-7894, the best barbecue in town with a secret rub and a delicious smoked flavor. We have a call coming in, and caller, this is David Tulis, and you're on the line with Boyd Patterson. What's your question or comment?
Great interview, David. I have a question, but first I want to make a comment. In covering trials over the years, I've found that in real criminal cases, it seems like the system is fair. But in political cases, it's rigged. In other words, where someone claims they have a right to travel without a driver's license, or in my case, where I fought the unconstitutional monetary system, or decided I wanted to be pro se, and so on and so forth. And instances where I actually won in court on constitutional issues, when I fought them again, the judge in many instances, in many jurisdictions, had me go last so people couldn't hear it. So my question becomes, when a patriot or a constitutionalist comes before you and argues pro se or in there for oneself, and argues an issue like the right to bear arms, and I don't see any authority at the state, local, or federal government passing any gun laws. As a matter of fact, I see it as treason if the state does that, because shall not be infringed is not ambiguous, period. And it's the Second Amendment, as there would be a restriction upon the First Amendment.
What's your question?
It would be voided by a court. So I want to know, as an individual that always takes the side of the state, would you be fair if a patriot or constitutionalist came before you and was arguing a case, or would you consider them a nut and not let them speak?
If I understood the question, as a prosecutor, my past has been in representing, seeking justice, and we do stand up for the state. However, the state includes people like you just described, sir. The defendant that comes before the court is a client of the state. Now, as I understood your question, generally speaking, when it comes to bad guys committing crimes, I think you said that the law tends to work, but when it comes to a political issue, maybe things in your experience have been a little different. I can tell you, as a judge, it will go exactly. There's going to be no difference in the level of fairness that's going to inure to all sides. Meaning that if a patriot or someone who believes that the law says one thing and there are arguments that it says a different thing, then that judge, what I will do too, that judge starts with what they're supposed to. What's the law? What is the law on that? And if the law prescribes a punishment, if the law prohibits certain things, then the law will apply. However, what I think a lot of people don't forget, what a lot of people do forget, is that there are constitutional challenges. Laws are supposed to be clear to everyone out there. And so if a law is unconstitutionally broad or unconstitutionally vague, then that law can be stricken down. See, that's part of the process too. Where the laws itself have built-in mechanisms of where the laws can be declared unconstitutional. That happens all the time. Those arguments occur frequently, and they have to be given merit.
This is David Tulis. Early voting starts today, and it ends February 23rd. You can vote early today for any of three criminal court contenders. Boyd Patterson is one. Mike Little is the second. Boyd is a prosecutor. Mike Little is a defense attorney. And Tom Greenholz is the incumbent. He's also seeking election. He was named to that post by the governor. Well, I think on the question of our caller, Boyd Patterson, the question is that when a constitutional issue comes before the court, it's often that the state is saying that this act or this person is doing something in commerce, and the person in reply says, "I'm not in commerce. I'm acting under a constitutional liberty. I'm not involved in any kind of equitable manner with the state." This, I think, comes up when we deal with the right to travel versus the operation of motor vehicles, which are two distinct acts constitutionally. One is in commerce subject to regulation by the Department of Safety and Homeland Security, and the other under no one's regulation, because it is, as I'm coming to understand, it is an exercise of a property right of travel, of locomotion, of self-propulsion. And so that's why the caller is asking about your proclivity representing the state in cases like that.
I've never handled a case like that. I've never had one where the commerce issue was invoked. I understand there was one recently in another county in Tennessee where I think it might have been a jury trial that the guy was found guilty under that. One of the great things about law is that you're always learning. And I would have to pretty much, I think, have a case that, and I'll tell you this, my learning has been from the cases as they've been brought to me. There's been sometimes when I've focused on a particular issue or rule of law, but if that case comes up, I guarantee that every applicable statute and constitutional provision, if it's raised by either side, will get the full attention of the court. Well,
this is David Tulis. Boyd Patterson is saying if he's elected by the judge, by you, my listener, and people on your street and in your county, that he will be fair to all sides. He will take the state's arguments, weigh them strictly against the Constitution and against the statute, and also that of the defendant in what a caller calls a political case. That would be one where an exercise of freedom is being asserted, and the state is saying, no, you do not have that right, that authority of movement or property. This is David Tulis. We'll be back in a minute with more from Boyd Patterson, questioning the deep questions, looking into the deep questions of law and liberty. He is running for a criminal court judge here in Hamilton County. I've got some messages I want you to hear. Hang on.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240.
Expect a very cold start to your Wednesday. I've seen a few spots too, so be careful. Otherwise, a little drier with some afternoon sun. Still cold, highs lower to middle 30s. Tonight, lows falling into the lower 20s. For Thursday, a slow warming trend with some sun, highs into the lower 40s, upper 40s on Friday. At GoDaddy, a domain name is the start of something awesome. You can create a website, open an online store, or start a blog. Get your .com domain name for only $2.99 for the first year at GoDaddy.com. And I'm S'mores Ian Twall, Chief Meteorologist Patrick Orr. On AM 1240, Hot News Talk Radio.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240.
What's going on? Get a free $20 gas gift card. Free. That's right, a free $20 gas gift card. Just tell Rick at Rick Davis Gold and Diamonds on Brainerd Road you heard the offer on Hot News Talk Radio. A $20 gas gift card for free. When you tell Rick you heard it on Hot News Talk Radio. Buy or sell 30 grams of gold or 10 ounces of silver and get a free $20 gas gift card. It's the Valentine's Day sale at Rick Davis Gold and Diamonds on Brainerd Road. 60, 70, 80% off when you buy rings, pendants, bracelets, and necklaces. Cash, 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 and more cash. When you sell all week, buy, sell, trade at Rick Davis Gold and Diamonds on Brainerd Road. Mention you heard this at Hot News Talk Radio and get a free $20 gas gift card. Free. Cash, cash, cash. This huge Valentine's Day sale's going on now. Don't miss it. Rick Davis Gold and Diamonds Valentine's Day sale. Rick Davis Gold and Diamonds, Brainerd Road, Chattanooga.
When it comes time to bug out, you need to know where you're going, and your phone just might not work. That's why you need to know how to read a map, and you'll need a map. $2 off maps at P5. 1 week only, $2 off maps at P5 Preparedness. 1 week only, $2 off.
P5 Preparedness on East Brainerd between Gun Barrel and I-75. Look for the Green Army truck, 423-602-2175. Look for us on Facebook.
Hello, I'm Mike Little, candidate for criminal court judge with 25 years of criminal court experience, which makes me the most qualified candidate. The experience I have gained from handling over 4,000 cases in state and federal court has equipped me with the ability to be fair, impartial, and independent. As your next criminal court judge, I will focus on keeping Hamilton County safe. I view this position as a public service and will strive to improve the daily operations of the court. I humbly ask for your trust and vote in the March 1st Republican primary.
Paid for by the committee to elect Mike Little, Barry Abbott, treasurer.
Here comes Dale Earnhardt Jr. He's got third. He's going for second. Earnhardt going for the lead.
The NASCAR Sprint Cup Series is on the Motor Racing Network. Coverage continues Sunday. Hear it live on the Motor Racing Network, the voice of NASCAR.
Check it out this Sunday live on Chattanooga's official NASCAR radio station.
Hot News Talk 1240.
Fox News Radio, I'm Lillian Wu. GOP candidates turning their attention to South Carolina the morning after Donald Trump's victory in New Hampshire. John Kasich placing second, but the battle for third was brutal.
Senator Ted Cruz, Governor Jeb Bush, and Senator Marco Rubio all finishing within a percentage point of one another. It was a disappointment for Rubio, who really seemed ready to take off after a strong finish in Iowa, but his poor debate performance on Saturday night really took him down.
Fox's Rich Edson, Hillary Clinton trailed Bernie Sanders by about 21 percentage points. She's hoping to do better in Nevada. The Fed chief says the pace of future rate hikes could be slowed, and a parole hearing today for Robert Kennedy's killer.
Sirhan Bishara Sirhan, a Christian Palestinian, was 24 when he shot and killed Kennedy in the Ambassador Hotel in Los Angeles over Kennedy's support for the state of Israel.
Fox Radio's Evan Brown, Fox News. We report.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240.
AM 1240 Hot News Talk Radio with your Hot News Now update. A Chattanooga postal worker has been arrested and charged by federal authorities with sexual exploitation of a child following a TBI sting operation in North Chattanooga, where they began monitoring websites like Meet Me and Kick. Prosecutor Tara Bay said that they were looking for adults who were trying to contact teens for sexual purposes. Police say the suspect thought he was talking to a young girl when actually he was talking to 2 TBI agents. Police arrested Jason Grandy on Sunday for allegedly invading his neighbor's house wielding a knife and harassing their neighbor's guest. The man and his wife, who own the home, say that they asked Grandy to leave many times. When he refused, the wife slammed him in the head with a cooking pan. He suffered from 1 laceration, which was cleared by EMS when they arrived. He is then taken to the Hamilton County Jail for processing. Authorities say that he was highly intoxicated. If it's going on in the Tennessee Valley, it's going on Hot News Talk Radio.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240.
Live from Chattanooga, Tennessee, it's Nooganomics with David Tulis.
We argue here at the station for the man who matters that near is better than far, that small is better than big, that simple outshines complex any day. And down in the footnotes in the 6-point type where the fleas fight with javelin and scimitar, we've got personal is better than corporate and physical than abstract. If it's going on in the Tennessee Valley, we allege and purport it is going on Hot News Talk Radio. My name is David Tulis. We are here talking with Boyd Patterson, who is an attorney. He works in the district attorney's office under Neil Pinkston. He's on leave for the moment to run for a criminal court judge. He's been in that office for 12 years representing the state. Every case that Boyd Patterson brings to the court, to the jury, or the court system is styled State of Tennessee versus John Doe. Okay, let's say that's you, my listener. Boyd, what is the state of Tennessee, and how is it that it has replaced God as the offended party, God's law being ostensibly violated by, let's say, a killing, and how is it replaced the victim, on whose behalf ostensibly the state is filing this case with the petit jury or the grand jury?
How about I answer that from a position from which I'm familiar? I can certainly say what the state represents to me. And the state represents anybody, any citizen in the state, any person that's brought before the court, as well as the victim. So when you say...
So the state represents the defendant, the alleged murderer, the accused, you're saying?
The prosecutor has a duty to the defendant, just as he does to society, just as he does to the victim. Absolutely. And that includes if exculpatory evidence comes up, if the case that's brought before you takes a turn, then ethically you have to fit the case to what the evidence shows, which could mean dismissal.
Okay, explain briefly what exculpatory evidence is and how that might damage your case as the prosecutor.
Again, it may be a semantic issue. It doesn't damage my case. My case is the truth. If any exculpatory evidence that's good for the defendant comes forward, it doesn't damage my case.
Right, that's evidence that tends to clear the defendant of the accusation.
Yes,
right?
Exculpatory evidence means that it tends to exculpate the defendant as opposed to inculpatory evidence, which tends to inculpate the defendant. So exculpatory evidence, if it's there and it's admissible, the jury needs to hear it. And I tell you, David, one of the things that I have to do when back when I was picking juries is explain that to the jurors. Typically, people see law cases and, actions in court as one side versus the other. I have to explain to jurors that as a prosecutor, my duty, as I understand it, is to seek the truth, seek justice, which means that I explain to them, that part of my duty is to present them evidence from the state that's exculpatory, that I will call witnesses that say the defendant may or may not have been there, I'll bring out testimony that if there's an eyewitness that sees the defendant, I will be the first one to say, and it was dark, and it was 30 feet away, and it was only for 5 seconds. And to be fair to the defendant, you'd never seen him before, and it took you a while to pick him out from the lineup. Those are things that tend to reduce the credibility of an eyewitness identification, for example. But I bring that out because that's what prosecutors are supposed to do.
Well, they are supposed to do that, but we read in the legal press how many times prosecutors are not that way. They're very ambitious men, and they want a victory no matter what, especially in the federal jurisdiction. But you're saying your modus operandi, Boyd Patterson, assistant district attorney, is to be fair to the defendant and the cause that for which you've assigned the state as your backer. You represent the state. You are the state of Tennessee, and you're saying that you don't have an ambition, and you don't have an ambition on the part of your boss, Neil Pinkston, who is elected, to make him look good by having his stats go up by conviction after conviction after conviction, some of which could be based on iffy causes and pressed arguments.
Let me tell you something about Neil Pinkston. Neil Pinkston is one of the first folks in the office to espouse evidence-based prosecution. Evidence-based prosecution simply means the evidence indicates what should happen, not anything outside the evidence. As you said, ambition or a political hot potato. That should not be part of it. It all comes back to the evidence. And since he's been DA and before that, it's been one of General Pinkston's philosophies. It all goes back to the evidence. If the evidence is there, proceed. If it's not, we can't.
So you've been Boyd Patterson, a prosecutor in good conscience. Your Christian conviction is not pointing fingers at you.
Could you rephrase that?
Well, you've been a prosecutor in the district attorney's office in good conscience. You've honored the code of ethics, and you've not had your Christian conscience point an accusing finger at you for
yeah.
Right.
Okay. Yeah, absolutely. It's one of those things where what you do as a prosecutor is probably what you do as a lawyer, and that is you work up the case. Your duty is different. So working up the case means finding the exculpatory as well as the inculpatory evidence and seeing where that lands you. So, yeah, there are things that everybody does that, you try the case in your head weeks after the jury comes back with a verdict. If I had done this, would have been different. But those are tactical decisions. As far as moral decisions, as far as ethical decisions, those are simple, but they're pretty clear.
My listener and you are in an elevator that has had a minor mechanical problem, and it's not a 45-second hike up to the top of the building, but actually a 4-minute delay as the red light goes on, and you hear this sort of muffled voice in the squawk box at the top of the compartment. What is it that you would say, Boyd Patterson, to my listener about your candidacy for criminal court judge?
Okay, yeah, that's great. If the listener is interested in experience as a prosecutor, then that's what I bring to that. When I say experience as a prosecutor, as we've alluded to earlier, prosecutors have the burden of proof, which means we have to prove beyond a reasonable doubt every element of every crime. What that means practically is that we have to prep up those cases to the nth level of degree. And so that experience of understanding the details of the law is something that I would certainly bring to it. I've written a book on 404B evidence, which is used across the state now. It's a very nuanced aspect of the law. It allows juries to hear evidence of other crimes that a defendant is being charged with. For example, it allows for gang affiliation to be brought in before a jury. It allows prior cocaine dealing convictions to be brought in a cocaine dealing case. I have trained prosecutors and lawyers at the local, state, and national level. I've published articles in the National Prosecutor magazine, and I say all that to say that I'm very familiar with the criminal justice process, and I'm telling you that this is a key position that can have an impact on this community. The second thing is that my background in psychology has always played a role in understanding the defendant's point of view, the victim's point of view. I would continue examining the underlying motives for crimes. It was very helpful when I was with the gang task force in crafting programs that keep kids from going to gangs in the first place. And the third and final thing I'll say is technology. I have an app on the App Store for jury selection that I designed. Designed the 5000angels.com website for the Children's Advocacy Center, which allows messages of hope and encouragement to be sent to victims of child abuse. Designed a couple of programs, computer programs that identify gang members in court. And finally, what may be most important to your listener as far as saving money In the court system, I was part of the team that brought technological upgrades to criminal court, which include video conferencing, which allows inmates to stay in jail in Silverdale rather than be transported, which saves transportation costs, i.e. taxpayer dollars, as well as increased officer safety. So the three things: experience as a prosecutor, understanding of the motives of criminals and victims, and an emphasis on technology.
My listener's concerned about injustice, particularly on the point, Boyd Patterson, of the victimless crime, what I call the paper crime, the crime where the offended party is no individual person. There's no body, there's no blood, there's no wound, there's no real loss, but there is an offense against the state, and that would be against the so-called peace and dignity of the state. Many people who are ground down, if you will, by the court system are poor. They are not people like you and me who have good grammar and we have all of our teeth. They are people who have two jobs. They have no cash. They rent the left side of a rundown duplex. They cannot afford an attorney. In a way, they don't deserve a public defender, the public defender in the plea bargain mill. They are all employees. Hardly ever are they entrepreneurs or capitalists or investors. They are accused of paper crimes that are inequity. In other words, they are accused of no tag, no insurance, no permit, no gun permit, no current license, or driving on suspended, a kind of case you had mentioned earlier. How is it that that you, as a judge, would deal with such crimes as this, which are not real crimes? They are mala prohibitas. They are evils by prohibition, not mala in se. They're not evils in themselves, which would be, for example, a rape or murder. Those are crimes that are mala in se. They're evil in themselves. And I would have to say that would come from the way God made the world, that these are evils and they're always evils. How do you make a distinction between those two types of crimes and the grinding down of the common man and the poor man by the court system? What do you say about these kinds of observations?
Well, I can tell you how I've come at it as a prosecutor. And that is, I've spent a lot of my time going after the criminals who are committing the malum in se crimes, those murderers, the child rapists, the ones who commit aggravated sexual battery, those types of folks. And the law itself, again, makes the distinction. You quoted the distinction as recognized by law. There are certain things that are prohibited simply because that's what the law says versus prohibited because everyone tends to agree. These are just bad things. And so further nuance is that the punishments for crimes that do not harm a person are invariably less. Now, if a person keeps committing certain crimes, the law does allow for the punishment to be increased. However, I can tell you as a prosecutor, David, when someone comes to me with driving on suspended license, the first thing I always ask them is, how long will it take you to get your driver's license? They could be guilty. They could have admitted it. They could have confessed. I did not have a license. It was suspended. It was revoked, whatever. But I will always ask them, how long will it take you to get your license back? And they tell me they pay off their fines and they'll get it back. Or they got to wait 3 more months before they're eligible. And I will pass the case until that time, let them get clear on it, and then I'll dismiss the case. And so that technically they're in violation.
What does that show about you?
What's that?
What does that show about you that you would pass a case like that, Boyd?
Well, I tell you what I believe, and you can make up your mind what other people, that your opinion on what that shows is for someone else to say. I can tell you that it's just fair. I think that it's better for society as a whole just to have people out there working rather than laboring under something that may be technically a law, but the law allows for discretion. The law allows for justice, and maybe that's wrong, but that's the way that I see it. I would rather have people out there, contributing to society rather than laboring under something that's relatively small and minor, but could be really jacking up their work history.
Well, it seemed the reason my question comes from observation of the kinds of people who are in courts. They are the people who cannot afford to pay when they have their beloved behind bars to pay for the online interview service that the county's recently adopted, that kind of skimming operation that takes advantage of incarceration. They can't afford that, so they have to show up when visitation time comes for their beloved behind bars to meet that person, because they can't make the payments for I think it's $15 for a half an hour interview online. They're people who are financially stressed, and so it seems to me that the court system is a kind of money making operation, whether it's on the civil side or the commercial side. And my listener has had some abusive treatment, and is concerned about that. So your answer to my question, Boyd Patterson, is that where lenity is allowed, especially when the crime is victimless, where there is no real injury, that you would go as far as you can toward restoring that person back to the workforce, back to his family, and not in harshness and absolute firmness of justice, if you will, insist that he spend the time behind bars.
Of course not. That's something that's, and I'm telling you, that's what I've done. That's what it is. And I think most prosecutors operate that way. I think it's very rare that, at least the prosecutors that I work with, for them to insist on something that's clearly, not beneficial to society. Of course you want people out there to then maybe get tripped up on their license issue. But yeah, of course you want the right thing to happen. That's what the purpose of the law is fairness and getting people to cooperate. I think if you want a one-word description of my philosophy on some of these topics we've been talking about today, David, it's cooperate. A lot of people think cooperation means giving something up. No, it doesn't. It means cooperate.
Which means that you would have an interest in restitution as a concept.
Yeah, which is also part of the law. And I have, that's something, restitution is something that if you can make things right, then guess what? Everyone gets to go home and continue with their lives.
Well, it seems restitution is a form of reform. What are the prospects of restitution being expanded as an alternative for judges in criminal cases, Boyd Patterson?
Expanded? I mean, can you give me an example?
How can the idea of restitution be expanded so that the accused and the convicted is not necessarily spending time in prison for his offense, but is allowed to find some way of restoring payment or services to the party he injured?
Oh, there's a number of ways to do that, and it goes back to the philosophy of what is the whole purpose of the criminal justice system? Is it to punish? Is it to rehabilitate? Is it to make restitution for the victim? And the restitution concept you're talking about is clearly embedded in the law. Restitution is part of the statute. And so what that does a couple things. One, it allows the defendant to make right whatever he's been unjustly enriched by.
Can you give an example of that?
Yeah, sure. Like, say someone writes a bad check, whether they did it on purpose, whether they should have known that there was no funds in that account. They wrote a bad check, they end up in court. But they also show up in court saying that they've never done it before, so it shows it is something that it was truly a mistake, even though technically it may be against the law. Again, the first question I have to the victim is, would you rather have him just pay you back, which would mean dismissing the case? Would that be okay with you? And if for whatever reason I find out there's no prior history, the victim just wants restitution, then I'll ask the defense attorney or the defendant, how long will it take you to pay back this $1,000 that you got that you shouldn't have? And so we'll pass the case, let them make the restitution, and the case gets dismissed. And guess what? Everybody walks out of there knowing that the right thing happened. The defendant paid back what he got, the victim gets back what he lost, and hopefully they'll never come back. One of the learning experiences of being in criminal court is you see what a grind it is. And you see you don't want to get caught up in that. Whether you made a mistake or truly did something intentional, you see that getting called to court all the time and what happens to other people in court is a lot of people don't want to be. So that itself can be educational and can be a motivating factor in people being more careful next time.
There are many weaknesses in the defense bar, Boyd Patterson. Are lawyers strict about requiring you as prosecutor to prove intent in a criminal act? Are you required by the defense to prove intent, or does everybody just ignore the whole idea of the necessity for intent for a criminal statute for there to be a conviction?
I love this topic. Intent is part of every single crime, and you have different levels of intent. For example, if your intent was premeditated, then that may mean attempted murder. If your intent was a knowing level, then it may be second-degree murder or attempted second-degree murder. If it was in the heat of passion, if your intent was, as a response to an understandably inflammatory situation, that's possibly voluntary manslaughter. If your intent is to act recklessly, then that drops it down to reckless homicide or reckless aggravated assault. And if your intent was simply negligent, that drops it down to negligence. Intent is an incredible concept. It's absolutely part of every crime.
And do members of the bar whom you face at trial do a good job in forcing you to prove intent, or is this somehow a neglected area of defense jurisprudence?
Well, again, I may sound like a broken record, but I put myself through that. I mean, as a prosecutor, I have the duty to look at those things, whether the defense attorney raises it or not. I have to look at it in terms of what's the intent beyond a reasonable doubt. Did he call his friend earlier and say, hey, I'm about to go shoot this guy? That's premeditated. Is there evidence that he was blindly walking down the street when he pulled out his gun to inspect it and it goes off? That might be more of a reckless or negligent thing. Doesn't matter what the defense attorney says. Of course, the defense attorney who's doing his job is going to make that part of the case. But in my opinion, in my interest is making sure that the intent fits the crime.
Boyd Patterson, how can my listener find out more about your campaign for Hamilton County Criminal Court Judge?
They can look at my website, boydpatterson.com. boydpatterson.com has a lot of the articles I've published, a lot of the background experiences I've had detailed. And if you want to know, again, the technology projects I've been part of, my philosophy when it comes to understanding motive, and my general experiences, you can go to boydpatterson.com and check out that information.
That's boydpatterson.com. Boyd, thank you for talking with my listener and me here at AM 1240 Hot News Talk Radio.
Thanks, David.
We are brought to you by P5 Preparedness, the prepper store on East Brainerd Road. That's P5 Preparedness. And that shop has many, many classes about being prepared for all kinds of events, whether bad weather, whether EMPs, whether a breakdown in the supply chain, in the retail sector, or other. That's P5 Preparedness. Duke Kumbelich, we also call him Duke Nukem, would be glad to talk with you about all that's available there. This is David Tulis. We've been talking with Boyd Patterson, a candidate for a criminal court judge. That's boydpatterson.com online.
I'm blowing everything up. We're starting over. I'm doing a new show. I want guys who push it to the middle of the table and go over the top. Take a risk, fail miserably. I'm right, and I'm not wrong, and I'll never back down. Conflict works. Allow it.
It's The Herd with Colin Cowherd, right here and everywhere. Noon Eastern.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.
News Talk 1240.
What are you going to get your sweetie for Valentine's Day? I'm going to Carter Shooting Supply.
Carter Shooting Supply.
That's right, Carter Shooting Supply. They're having a great sale on all of their guns right now, and it's name brands like Smith & Wesson, Ruger, Springfield, their AR-15s. They've got the hottest gun in the land right now, the Sky 9mm. Man, it comes in all the cool colors. If you're an Alabama fan, they've got crimson. If you're a big orange fan, they've